Hey, good morning, good afternoon, good evening, everybody. How are we doing? It is time. It's time for a new trial. I've been keeping this one a little bit close to the vest. Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your Constitution does not apply to me because I'm a sovereign citizen, a traveler on the land. I'm from the Moorish Empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and then just get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. God dang, you're right. Moorish Empire. Traveler on the land. Bitch snitch. Moorish Empire. God dang, you're right. Traveler on the land. Bitch snitch. The late evening U.S. people. No, good morning, good afternoon, good evening, everybody. It's me, Legal Vices, and welcome. We're going to put this away here for just a quick second because we got a bunch of stuff to do. I'm so glad you're here. It's Tuesday, and it's time to get down and a little bit dirty today. The only person with an introduction longer than mine is Megan Fox.
I love it. I love your new intro. Oh my God. Oh, I love it. And I think you should add 30 more seconds at least.
Yeah, no, I'm looking at it going, when the fuck is this thing going to end? Even I'm doing that. But
I love it.
It is Tuesday. We are here. We got some stuff to get into. We are getting into the Clayton Echard Jane case here. We're gonna now see. Look, when Dave was on last week, I caught a little bit of flack. You people going, he doesn't get it. He doesn't understand. He's not supportive. Look, I'm at the beginning. I'm fair. I'll give equal opportunity to both sides to hear both sides of the story. And exactly as I predicted, crickets from the plaintiff side of this. I didn't even get a nasty gram, so I feel kind of left out. But I know, I kind of left out. But hey, the offer was open. All she's got to do is come on here, bring all of her documents, all of her filings, bring all of her submissions to the court, and just tell her story. That's all I wanted. That didn't happen. Hey, so all I can do now is go off of what I got in front of me. So take off the proverbial gloves, and we're going to get down to some business today. We got a lot of stuff. We're going to be reading a bunch of court documents, as many as we can in the next 2 hours. That's what we're going to be doing here on this festive Tuesday. And we've got Megan Fox, as she said, just to cackle alongside me.
That's all I'm doing. I'm just here to laugh while Jeff reads.
Yeah. So very, very quickly, a little bit of housekeeping stuff. Tomorrow, do not miss tomorrow. Tomorrow I will have Greg Anderson, Maya Kowalski's lawyer, on here, and we have some shiz to talk about, some unexpected shiz. But before I do it, Megan's going to talk about some new stuff right after this. When we finish here, I'm going to pop on over to Megan for a bit, and she's got some breaking news in the Maya Kowalski case. Like breaking news, like news that nobody else knows about at this point. And then I'm going to be hitting it with Greg 24 hours from now. So keep that in mind. And when we're done here, we're going to feed right over into Megan Fox. So we're good for that. So that's tomorrow. Greg Anderson with a little bit of his story, a little bit of trial talk, but also some of the huge breaking news that Megan Fox is going to break. And then what day is that? It's Thursday. Thursday is O.J. Simpson Day. Chandler Remington and I are going to be continuing to watch Johnny Cochran's closing arguments in the Johnny Depp case. And then on Friday, do not miss Friday. Friday is the F It Friday stream where we just say F it and we drink a lot and you throw money at me, but we'll talk about that later. Don't want to get too far afield right now, but without further ado, let's take our like and subscribe poll. We got 227 of you here already. You guys are in for a treat. Today, we're going to be breaking down the documents from Clayton Echard in the case filed by Jane. No! I will never get old, ever. It's not ever going to get old. But before we do that, make sure you hit the like button. Make sure you hit the subscribe button. If you're already subscribed, make sure you're still subscribed. And then pop on over here and take our little like and subscribe poll, which I forgot to title as the like and subscribe poll.
Oh, shit. I forgot to do that. I'm going to go do it right now.
What is the weirdest part of this case? Jane. No! Fetal attraction. Mouth conceptions about pregnancy. Or just a whole...
Conceptions?
The best I could come up with.
Mouth conceptions. Oh God! Oh, I'm broke already. You've broken me already, Jeff. Oh my God.
I'm sorry, chat. I didn't mean to do this so early on in the day, but I was trying to think like it's like immaculate conception times 2, like trying to outshine perfect. Jesus. But then I figured there's nothing immaculate about this. Well, anyway, mouth conceptions about pregnancy or just the whole damn thing. We'll check in on about an hour or so and see how the vote's going. But yeah.
Oh, that's good. That's good. And I thought I was funny coming up with fetal attraction.
You were.
But mouth conceptions. That's good, Jeff. Damn.
Well, I liked yours too. That's why I used the boiled. So.
Hey, Dave. Dave's in the chat. Dave Neal.
Where are you at, David? Oh, there you are.
Did she have the babies yet?
Nope. That's one of the many mouth conceptions we're going to be busting today. Jane and the many mouth conceptions.
She needs to write that book. Maybe she can recoup some of this loss.
There's these kind of comedy fantasy novels by a guy named Robert Aspirin called like Myth Conceptions. He goes through like Mything Link, Myth Conceptions, another fine myth you've gotten me into. And I thought, mouth, hey, I know.
Mouth conceptions.
Dave, I hope you've got the move all completed and everything out of the way. Not too much snow along the way, but we're great to have Dave here. Like I said, we were fair, we were balanced. We gave her an opportunity. She didn't come forward, so now the goal lines have shifted. As far as I'm concerned, she's given up any right to complain about how we represent her case because she's chosen not to come on here. And we know she knows about it because apparently she's lurking around everybody. So we're going to start pretty much on her goal line today because I got nothing. I can't even make devil's advocate arguments on her behalf because I ain't got nothing she submitted. So
well, Dave says he's dropping some spicy stuff on his Instagram today. So if you guys are he's at Dave D Neal's DNEALZ on Instagram if you want to follow Dave over there.
Grifter wannabe mouth conceptions of the third
kind.
Megan's meme. I need a Close Encounters of the Third Kind with Devil's Tower meme. We need a Devil's Tower mouth conceptions of the third kind. Megan's locals.
Are you listening, locals?
Calling Megan's locals. I expect this within the next few minutes.
There is a chat. There is a live chat happening right now on locals for this stream. So we hopefully will get some memeing going. I don't know how many people are in there. Is it too early? Come on, guys, wake up.
Yeah, it's got to be good because I plan on using the mouth conceptions of the third kind with the Devil's Tower, the movie poster, in future thumbnails. So make yourself famous. Right. Oh, Lordy. We're off to a good start today. Oh, I usually keep Twitter open. I gotta close it because like the first 3 videos are people getting shot, hit by a bus, and falling through gratings. What is wrong with Twitter? Or what's wrong with my Twitter feed? I guess it's probably more accurate. There we go.
I don't know.
Right. Well, we are here, Megan. Welcome.
Thanks.
MeganFox.locals.com. Everybody go over there and make sure that you are subscribed to her. And Dave Neal here, make sure you go to Dave Neal Comedian and sign up for him and subscribe to him and like all of his stuff if you are not already. He is the king of Jane and the mouth conceptions.
I need that button. Damn it.
Never going to get old. He's the one that breaks all of this. Then Megan, she sends me a text at like 2:00 in the morning. Oh my God, look at this. Oh my God. And then that's how I came up and got involved here. So allegations have been made.
Welcome. And you're welcome, Jeff.
The gift that keeps on giving. And before we get started, we had a pre-super chat. Anybody wants to send your super chats, go right ahead. We'll read them as they come in. Joe Choi started us off. I can't even, she was in so early that I can't even bring it up. Oh, yes, she's the very first one up there. There we go. Joe Choi, I should make the stream today. It snowed. Well, hey, Joe, welcome. Happy for a snow day. If it's snow day is what it takes to get you in here in super chat. Cool. All right. We are now 90. Well, actually, we're like $85 away from unleashing Doggo Cam. All right. Let's get on with this. We've talked enough. We've grifted enough. This isn't a grift stream.
Has it been 17 minutes yet? Or do we need to have
12.
a few more minutes of bullshit?
No, we're pretty good with 12.
We're almost there.
All right, I know. So anywho, as I was saying, the super chat's not required, not even really encouraged, but if you do send something, it's guarantees I will see it, and I and possibly Megan Fox will respond to it depending. So that's it. Let's bring up the first deal. We've had these allegations. We've had these allegations against Clayton Echard that he has impregnated a woman somehow. All she says is through intimate contact.
Mouth conceptions, if you will.
Well, she wouldn't even do that. But thankfully, the first submission we're going to look at today is this document right here. This is the Notice of Filing Affidavit of Non-Paternity. This is Clayton Echard telling us exactly what happened in very short, easy to understand, mostly single syllable sentences. So this was filed on 12th December 2023. Scrolling. Here we go. Exhibit A. Affidavit. I'm going to bring this up because my eyes are old. There we go. Affidavit of non-paternity. I, Clayton Echard, being duly sworn upon my oath under penalty of perjury, depose and say, 1, I have never had sex. Oh, sorry. That was a different guy. And I have so-and-so. Oh, we can do this. Jane. No! And I had one sexual encounter on May 20, 2023, where she performed oral sex on me. She wouldn't even say what kind of sex they had. She just said intimate encounter. But he's dropping the heat in the first damn sentence. She performed oral sex on me. We never had sexual intercourse or engaged in conduct that could lead to conception. First mouth conception busted. Ladies, if you want to prevent yourself from becoming pregnant with twins, use a dental dam. What? That's not how it works? All right, whatever.
Oh, sex education has really failed in this case.
Penitent tangent, trouser-friendly kiss. Wow. All right. Jane continues to claim that I am the father.
This case was made for LawTube. I swear to God.
That's correct.
Clayton, I am your father.
That is correct.
Not. You can still say not, or did that like actually go out of style 40 years ago? Anyway, I'm a child of the 80s. What do you want? I do not believe she is pregnant, and certainly not pregnant by me. Why did Maury have to retire? Damn it! He could have settled all of this. So one,
mouth hugging.
I was like the alien thing.
The one-eyed trouser snake. Oh God!
Wow. Oh, see, now we need a gif of like you're the alien, the face hugger putting its ovipositor down her throat.
Oh God! Okay.
We're gonna get. This is one page, and we're probably not even gonna get through this in 2 hours. Lordy. Hey, welcome 400 people with 200 likes. 200 of you haven't done your job. Get down there and smack that like button.
Don't make me shame you.
Just poke it like you're trying to impregnate it with twins. I'm sorry. I should be better than this, but I'm not. So, had oral sex, did nothing that could have led to conception. I do not believe she is pregnant, and certainly not pregnant by me. Attached here to, pursuant to the rule, the Arizona statute, the putative father registry. Now, this is a shit. This guy is actually forced to register as a possible father to ensure that he has the rights to deny this going forward. Because if he's not registered as a father, if nobody is registered as the father, she can do whatever she wants.
Isn't that interesting? So he has to register as a potential father of non-existent twins just to make sure she doesn't get away with it. This is interesting legal stuff, isn't it, Jeff?
Yeah, I mean, it is. I mean,
it is.
Literally,
I've never seen this before.
She can say, I had an abortion. She can say, I gave him up for adoption. She can say anything she wants. But if he registers as a putative father on the registry, then at least if she actually did have kids or something did happen, she would have to get his consent to send him up for adoption or whatever, because he is the putative father. Even though he says, I've registered. Here's a notice of claim to paternity. To be clear, I dispute the interaction between Jane and I could have resulted in a pregnancy. I'm concerned that if I do not file with the putative father registry, she will use her social media platform to claim that she had my children or that she somehow put them up for adoption to explain their non-existence. So as we said, he literally has to register as a potential father of non-existent children in order to prevent her from saying that she just gave them up for adoption. That's why they're not here. That's messed up, but welcome to the world of law. And number 5, consistent with filings in family court in Maricopa County, under cause number of this case number, I am asking the court to make specific findings of non-paternity. So that's what he's asking for. He's just asking for a declaration that, Clayton, you are not the father of non-existent children. That's the first document. That's right Jeff, out of the gate. Yes.
If you want, the chat should be playing bingo along with us as we read this.
Oh, cool.
It's pregnancy mouth conceptions bingo. We have here.
That was quick.
Well, it's oh look, Megan's unhinged cackle. Well, we can already cross that one off. Which of fun voices? We had that one already too. Nicholas appearance. We've got bamboozled court judge, false pregnancy test. Dave Neal appearance. We got that. Dave showed up.
Yeah. He's in
Cluster
chat.
B disorder. Cease and desist. Fake crying twins. Hoodwinked law enforcement. Mouth babies. Poorly written legal documents.
I think we've got mouth babies. We got mouth with mouth.
We got mouth babies. Okay.
Yeah.
Free Jane Doe get wrecked. That's our free space. Oh my gosh! All we need now are poorly written legal documents, and we're at bingo already. All right. So if you want to play along,
see, that's unfortunate. We don't have her documents. Otherwise, there would be poorly written documents.
True.
But, all right. Well, let's continue here, and we'll check in after this next filing.
All right, I'll keep an eye on the bingo. Don't worry.
All right. This, let me embiggen it, is the motion to extend dismissal date on inactive calendar and schedule an evidentiary hearing. This was filed in December as well. So at the time of this filing, she still had mouth babies. They hadn't disappeared yet. They disappeared when she got her new lawyer somehow, like literally the same day. How weird, how awkward is that? But what we've got here is him giving his reasons why he wants an evidentiary hearing and why this should be continued long enough for him to get his day in court. Quite literally. How are we doing here in chat? No monthly chats, no super chats to get through here. What's the free space? We got that. Reddit does not have her filings. At least not the Reddit community we have. So that's the magic we're waiting
her
for.
Filings. We would love to see her filings. Boy, wouldn't that be great?
And with Maricopa County, what it takes is someone actually going to the courthouse to get them, which costs money and is a pain in the ass. So I swear life is a South Park episode. Chad is making me unalive from laughing. Chad is good. We love Chad. Right. Okay. Time to continue on. Oops, I've almost clicked the wrong button again. There we go.
Stop touching buttons, Jeff.
Just have to rearrange my windows. There we go. There. Now they're all spread out evenly. All right. Respondent Clayton Echard by and through undersigned counsel, he files the expedited motion to continue the inactive calendar and schedule an evidentiary hearing. The motion is expedited as this matter is set to be dismissed on February 2nd, 2024, and respondent is entitled to an adjudication/finding of non-paternity. The background. Here we get into a little bit more of the details as to what's going on. Dog snoring. Sorry, if you hear the dog snoring, hey, it's not me. Background. Petitioner has never underlined provided respondent with any substantive proof of her alleged pregnancy, and all paternity tests have indicated there is little to no fetal DNA. Doesn't sound much like a preggers to me, but Respondent maintains that the sexual activity that took place was not conducive to a pregnancy. I just love I love how we just dance around. You ain't getting pregnant from blowjobs.
You guys forgot to put Krusty Clayton's on the bingo. I'm disappointed. We could have already had that.
No, thank you for not putting that on there. There are lines. There are lines. It's like the old church story of the guy goes for the job interview about they're driving trucks through a mountain pass. Like, how close to the edge can you get without falling off? And they're like, oh, I can get this close. I can get a millimeter. I can get half my tire over. You give the job to the ones like, I'm staying as far the fuck away from the ledge as I can. This is kind of on the line. We don't need crusty anything.
Still disappointed.
All right. Well, background. Petitioner. Okay, this is the sexual activity that was not conducive to a pregnancy. Nevertheless, and as recently as December 8th, petitioner continues to publicly maintain that she is pregnant with respondent's, quote, twins. Respondent believes the pregnancy has been fabricated as a means of harassing respondent, who has an injunction against harassment against the petitioner. Yeah, she tried to get an injunction against him, which didn't work. He got one against her. Or did she? I can't remember. I don't think she got the restraining order against him, but I know he got his against her.
No. So she did against Clayton. She did. I think he.
Oh, she got it.
I'm pretty sure they both have one against each other.
Yeah. That comes into
and she got hers. When he told the story about how she got hers, he had actually filed first, but the judge pushed it off for whatever reason. There was some technical reason. As soon as she filed hers, right after that, the judge granted it, of course, because she's a woman. And, as soon as a woman says, I'm threatened by this big, scary man, the judge is like, okay, whatever.
Don't talk with your mouth full, lady. Not you, her. Yeah.
I'm like, wait a minute. What?
Not you. Jane. No! Right. So the pregnancy has been fabricated as a means of harassing respondent who has an injunction against harassment against petitioner due to the harassing nature of her communications with respondent. Due to petitioner's relentless assertions that she is pregnant with respondent's twins and repeated outreach to the media and the alleged and very disputed pregnancy, respondent is entitled to a judicial finding of non-paternity. As for his motion, respondent states as follows. This matter has been pending since petitioner Jane filed a petition to establish paternity and legal decision-making, parenting time, and child support.
That takes balls, man. It takes balls to file a petition for parenting time and child
support
with no
legal
babies.
Decision-making. Good God, woman. Petitioner also subsequently filed a motion to communicate and motion for contempt, attempting
I want
to coerce
this judge to force you to talk to me.
Seriously, make him communicate. Respect my authority. Attempt to coerce respondent into communicating with her prior to the birth of the alleged and believed to be entirely fictitious twins, predating and
believed to be entirely fictitious twins.
Not just a little bit fictitious, entirely fictitious.
I love the way this is written.
Oh, it's good. Yeah. Predating an injunction against harassment. Both of these motions were denied by the court. Denied. Buddy Christ. Denied. All right. Notably, petitioner testified under oath without medical support at the injunction against harassment hearings that the twins are due on, of course, Valentine's Day. February 14th.
Oh my God. Why didn't the judge just look at her due date and be like, I don't believe you?
Yeah.
I mean, come on.
I think you might have a button to push for that, don't you?
I might.
I thought you have an I don't.
Do not sit down.
That's it.
Petitioner, as footnote 1 says, is correct, has an order of protection against respondent that permits the parties to only speak about the family court action. Petitioner has repeatedly called the police to report the respondent is violating the order of protection, despite respondent clearly indicating he has no desire to communicate with the petitioner. No charges have ever been furthered against respondent. Ooh, Unhung Hero with a $2 super chat, moving us ever closer to unleashing the doggo cam, says Jane. Oops, I wasn't ready. Jane Doe or Jane Doe. Oh, I don't have a cash register cha-ching. Damn.
I do.
Okay.
Wait, I do.
Let's do this. All right. Jane Doe or Jane.
Oh, whoops. I hit it too early.
Medium smart Megan Fox, everybody.
Sorry. My button game is off. Ruin that one.
All right, let's go.
That's what I'm here for, Jeff. To ruin all the good jokes.
I'm so drunk I can barely see, but it helps me get through another day.
Respondent timely filed his response on or about August 21st, 2023. Contemporaneous with this filing is respondent's motion for leave to amend respondent's response to petition to establish paternity. We're going to be looking at that in a bit. Petitioner has not provided scientific proof that she is pregnant. She hasn't really. I was actually thinking of this. The twins are Arnold Schwarzenegger and Danny DeVito. I was actually thinking that about 3 minutes ago.
Oh, God.
I was actually thinking about that. Petitioner has provided a video of a sonogram that appears to have been borrowed from a YouTube video from 7 years ago. Now, Dave Neal that's the crowning glory of the sonogram department. Go back to Dave Neal's page, Dave Neal comedian, and check out the sonogram video where they take her sonogram and a sonogram that was just uploaded randomly to YouTube 7 fucking years ago, and they are freaking identical, except for the weird font that's used for the Jane Doe sonogram, and the fact that her timestamp on the sonogram does not move. It has the exact same timestamp for the entire goddamn thing. Also, there is no way that is real.
Something on the sonogram that's also really bizarre is she put the date that they got busy. The date of the blowjobs. That is not the date. They don't put the date of conception on your sonogram. They would put the date of your last period, not the date that you think you got pregnant, because it's all like a guessing game anyway.
And if I recall correctly, back in the dark ages when my son was birthed, they would have like approximately 4 weeks, approximately 6 weeks, or something like that. They wouldn't have like the date of conception.
Right. No, they don't. They never they always give you like a date range where they think you might have conceived, but on the sonogram they would never put the date of conception. That's crazy. Check your DMs on Twitter. That was from Locals for You, but I don't get it. Maybe it's a movie reference I don't understand.
I don't want to get it. I don't know. All right. Petitioner has not provided any scientific proof that she's pregnant. Yeah, it's just this 7-year-old video of her show. 7 years old this sonogram is. If you haven't seen it, that is an absolutely wild video. It's insane. She just took allegedly a sonogram that's 7 years, and it matches up frame for goddamn frame with this 7-year-old thing. And then a video showing her pregnant stomach, which is believed to be edited and or depicts petitioner wearing a fake stomach, screenshots of alleged appointment dates with doctors. She can't even provide evidence of going to a damn doctor's appointment. And or depicts petitioner wearing a fake stomach, and multiple positive HCG tests.
Oh, you know what somebody brought up yesterday?
What did somebody brought up yesterday?
I went over that video that she posted on Facebook that I sent you, the Amber Heard crying. Well, in it, she says, or in one of her emails, she says that she brought in a fertility clinic, that a fertility clinic came in and she knew she was fertile. Somebody on my YouTube said, what if she took injections, HCG injections, from went to a fertility clinic, told them she wanted, therapy or whatever, and what if they were giving her injections? I wonder if that's a thing that could happen. It seems legit to me.
It could be. Could very, very well be. And JKD Buck 76 says, question, is her daddy rich or very influential? Yes, he's rich.
And he was influential. He was a famous radio host in San Francisco.
And Unhung Hero with the $2 more. Thank you so much. At what point does this become criminal?
At no point will it become criminal because the cops do not care.
Well, I mean, at most it's going to be like stalking or harassing or something like that.
They've got murders to solve. They've already said they don't care about this. Clayton went to the police. They said go to the DA. He went to the DA. The DA said go to the police. Nobody cares.
Yep. This is a civil matter.
If it were happening though to a woman and she was being stalked and harassed and by a man, believe me, he'd be in jail by now.
Well, let's get back to what she hasn't done. The long list of things she hasn't done. She has not provided any verified sonogram reports, fetal anatomy scans, which are required at 18 to 22 weeks, sonogram images from various checkups showing the progress of the pregnancy, or any additional medical information that would be typical of the high-risk pregnancy with twins the petitioner is claiming. Nada. She got nothing. Ain't nothing there she's putting out. MG Law says, so she was fertile from treatments that she got pregnant from oral. She was so, that should be like, she was so fertile from treatments that she got preggers from oral. Yep. Pretty much.
Oh, I get to click off false pregnancy test. Perfect.
Sweet. Okay.
We're working on that bingo.
All paternity results have come back showing little to no fetal DNA. That's not the result you want if you're like 23 weeks pregnant with twins. The company that has been conducting the tests, Ravgen Inc., has conducted at least 3 paternity tests, 2 of which have shown little or no fetal DNA, and 1 was allegedly lost in transit.
Because of weather. So the weird part is it's because of weather. Just like that guy in the Kowalski case who's the hurricane ate his reports. Remember? Yep. So a hurricane or a tornado or something ate Jane Doe's pregnancy paternity test. It happens.
Brittany Gibbs says, didn't they teach her in school not to swallow so you don't get pregnant?
Do not do that to me when I take a sip of coffee. That almost went all over my keyboard.
Yeah, well, that's it's like Irish twins, except they're tonsil twins.
Tonsil twins. Oh my God. Oh, that's got to go on the bingo sheet next time. Tonsil twins. Oh.
Wow, we need like a Thompson twin song. If I could create life in one day. Back from the 80s, the tonsil twins. Oh dear, we're off to a good start today. Yes, I am giddy because I don't have to be nice today, because now I'm looking at, by the way, if you happen to be watching this, little Ms. Jane, these are public documents filed publicly in a public court where public proceedings happen in the public. These are not top secret. These are not sealed. These are not in any way forbidden for anybody, any I almost said blowjob to walk off the street, but that would be weird. Joe Blow is what I meant to say, but it almost didn't come out that way. It almost didn't. Yeah. Any Joe Blow can walk off the street and go, I want the copy of the record in this stupid ass case, and they'll give them to him. So that's what we're reading. And guess what? All of the attachments, all of the texts, all of the emails, all of the weird letters, all of that shit's part of the record too. And you better be damn straight. We're going to be looking at those as time goes on.
And you can protest. You can bring your little sign down to the courthouse and do this.
We want privacy. We want privacy.
But it's not going to make any one bit of difference, honey. Just not at all.
Nope. None at all. So Ravgen is apparently in the habit of losing their paternity tests. If you lose 33% of your tests, that ain't good for business. All right, what? What, Megan?
Nothing. I'm just laughing at the
all
33% because it's true. It's like, it also makes me think this, like in the last couple of days, some of the Redditors, who hate me and think that believe women is a good idea still, they say things like, false allegations are only 2%. It's like, well, this one woman has made at least 3% of all the false allegations in Arizona all by herself. So it's got to be higher than that, Reddit. The false allegations statistically must be higher, at least in Scottsdale, Arizona, where this woman operates, because she's made at least 3 false allegations. So, and
my understanding is she's responsible for 50% of the allegations against Clayton Echard. So,
yes, she is. He's had 2. Unbelievable. Yeah. This guy has bad luck.
I'm just glad I'm not rich and super hot and played professional football.
There are some things to be grateful for. Those of you
men
out there who are, you're upset that you're not 6 feet tall and good looking. Well, just imagine you're not the target for this kind of bullshit.
Yeah. So they've lost 33% of their tests, allegedly. Ravgen Inc. does not provide written reports without a court order. Exhibit 3 explains the DNA process. Upon information and belief, Ravgen Inc. is waiting on a 4th test before they can complete their report, but petitioner has not cooperated. Why would you not cooperate with the 4th test necessary to complete your pregnancy report in the lawsuit you are bringing against someone for all of their money?
She actually didn't want his money. She just wanted to force him into a relationship with her. It's really quite sick.
Yeah, we'll get there. That's weirdness, isn't it?
Very weird. Oh, and also, Clayton had this conversation with Ravgen, and apparently he kept asking them, like, how come it's not enough to have 1 test that says little to no fetal DNA, or even 2 tests to say little or no fetal DNA before you say this bitch ain't pregnant? And they were basically like, well, that's not our job. We actually don't tell people whether they're pregnant or not. We do paternity tests, and we've never dealt with someone who wasn't pregnant, so we don't know how. So we need like 5 or 6 tests in order to definitively say, like it's not our thing.
Nut job. Figuratively and literally, I guess. The jokes in this case just write themselves.
I know. This is why this is made for LawTube. I'm telling you, this is why I was like, you guys, wake up, read these documents. This is just right in all of your wheelhouses, I tell you, from the juvenile jokes that it brings up to there's just so much here.
She's crazy. I've never met the woman. She's different. She's stupid. She's weird. I don't understand her. She's not the right one for me. Respondent has registered himself on the putative father registry. Respondent has been forced to register on the putative father registry out of fear the petitioner will use her social media platform to further promote her false pregnancy narrative. The respondent is entitled to a finding of non-paternity. Petitioner began this action in bad faith, meaning she knew she wasn't pregnant when she said she was and filed the lawsuit. So that saying they're doing something in bad faith means that you had evil intentions, you had evil plans and stuff from before the filing.
Yeah,
right from
knowledge.
Jump. Based on an entirely fabricated pregnancy. Petitioner will continue to claim she is pregnant with respondent's children unless this court enters a finding of non-paternity and dismisses the case with prejudice based on that determination. And dismiss with prejudice means you can never, ever, ever file another lawsuit about this ever, ever again. This matter should be continued at least 60 days to allow respondent time to receive discovery from petitioner. And this is, the discovery process is where I have to turn over all of my shit to you, and you have to turn all your shit over to me, regardless of whether it supports my claim or is negative or adverse to my claim. Both sides have a duty to reveal everything to the other side. Flux caught the joke. Good for you, Flux. This matter should be continued at least 60 days to allow respondent time to receive discovery from petitioner. Petitioner, contrary to Rule 49, has not provided any disclosure to respondent. She hasn't turned over a single document that she is required by law to turn over.
That's always a problem.
Yes. And because she hasn't, well, though respondent vehemently denies the petitioner is pregnant by him, he is entitled to discovery that includes verified, not edited or otherwise fabricated medical records. Well, that sounds reasonable.
It seems reasonable to me.
Can we please have verified, not edited, or otherwise fabricated medical records, please? Pretty please. Eric Foam says, if she is no longer pregnant, where are the kids? Well, she is no longer pregnant, but we don't know because she hasn't said. She just said.
Well, she did say she's no longer pregnant. We just don't know if there were babies. Where the hell are the babies? Where are the fetal death certificates? She's going to have to answer for that.
Yeah, we're going to get to all this. If she's no longer pregnant, due on February 14th, the babies would have been viable. Oh, yeah, she would have to have a certificate of death at that point.
After 20 weeks in Arizona, that's the law. And she was at the last court hearing, which was on November 3rd. She claimed to be 24 weeks pregnant. So, that ship sailed. And she said 100%. She was 100% 24 weeks pregnant. 100%.
She went into remission. I'm sorry, I'm laughing. I can't click to hide this thing. There we go. No, oh god, there we go. She's in baby remission. All right, so she hasn't given any of the discovery. Respondent requests this court set a virtual 30-minute evidentiary hearing on the issue of paternity, non-paternity, attorney's fees, and Rule 26 sanctions. They want money and they want the other lawyer to pay. Mm-hmm. Based on petitioner's unreasonable behavior in filing this action without any scientific proof of pregnancy and continuing to publicly claim she is pregnant by a respondent, requests that she be ordered to pay his reasonable attorney fees and costs incurred in this action. Wherefore? Respondent respectfully requests the court to enter the following: issue an order continuing the matter on the dismissal date for 60 days, schedule an evidentiary hearing on the paternity and non-paternity fees and sanctions, and award respondent the attorney fees and costs, and any other order the court seems to think is appropriate, including sanctions. Now, following this, we have a ton of other documents, and we'll get to them if we have time. I want to read mainly the submissions today. If we get through those, we'll go back. But then later, we'll go through and look at the documents that have been submitted by Clayton about her. That's kind of what we have planned for the next one. We'll see how much we can get through today. So we'll flip the script here. Let's see. We've read everything we've got to read. And, well, that explains the noise.
We need the doggo cam so we can see the noise. I feel like one of the dogs is chewing on a bone or something, and I feel cheated that I can't see it.
A plastic 2-liter bottle.
Oh, those are so noisy.
Yes, I know. So, well, I'm going to let you read this first part while I go remove it from her possession.
All right, are we starting at pursuant? Pursuant to Rule 28A of the Arizona Rules of Family Law Procedure, Respondent Clayton Echard, through undersigned counsel, respectfully requests leave from this court to file the amended response attached hereto as Exhibit A, which clarifies the modifications that respondent is requesting. The reasons for this amended response are as follows. 1. Rule 28A provides that leave to amend will be freely given when justice requires.
Oh, dogs are just like children. Here's your really expensive toy. Okay, let me play with the wrapper.
Or
cats.
Mine loves empty milk gallons, and if you leave an empty milk gallon around, which we reuse them for things, so if I accidentally put it in his reach, he will take that thing, throw it all over the house, chase it, bat it around, and it's the loudest noise you ever heard.
Okay, Sasha. That's 5 minutes in the penalty box. That's crossed the line.
Shredding Chris twins. Oh my God, that's fantastic. God, we have the funniest chat. Funniest chat ever.
That's go to the penalty box. That's 5 minutes for instigating. That's terrible. Oh no, Schrodinger's twins. Yikes.
Oh Lord.
My face hurts already. M. Young, bringing the $2 heat. Show the dogs, or I blame all noises on.
Fair. I think that's fair.
Thank you so much for the support. We're getting there. We're what 75 away.
Awesome.
Anyway, we are.
Release the hounds.
But today isn't a grifty stream, so if it happens, it happens. If not, it doesn't. All right. Number 2, respondent's amended response is attached as A. That's the lengthy document where he's giving his amended official response to her complaint. Note, for clarification purposes, the amended response is not provided on the self-service documents and that were initially filed. Any changes are bolded and remainder remains consistent with the initial filing. So when we get to that here in just like the next line, the next page, all of the normal type stuff is what was original, and then he added some darker underlined bolded stuff in the amended filings. So specifically, respondent seeks to amend his response to include pertinent background information for the court. So we get more background information. All right, so scroll on down here. And at this point, she is pro per. She's between lawyers. I can see her.
What date was this? What date?
This was the 12th of December. So her.
Okay. So she's got a new lawyer now.
Well, she's on her second lawyer since this time.
Third.
Well, she had this one. This lawyer left. Then she was alone for a while. Then the next lawyer came on, I believe, and that was the one that filed for the dismissal, and then immediately left. Got the new lawyer. The baby disappeared. Oh, and that lawyer disappeared too, right?
Yeah, but no, she has a new one now. Yeah, she has her third lawyer.
Oh, yeah, it's her third lawyer, but yeah.
His name is Clay something, and poor guy, he has no idea what's going on, I'm sure. He's like a discount lawyer, and so she's down to the bottom of the barrel, I think. No offense against discount lawyers. I'm sure that he's a decent lawyer, but I just feel sorry for him because I don't think he did his due diligence on his new client.
Speaking of due diligence, chat, I told you now. Joe Choi says, closer. Thank you so much. And then Sonia Chris has got us to that point, which we like to call.
Nice. Doggo cam. Doggos. I love it. Now we have to give the dog the bottle back because that sounded entertaining.
It wasn't. I wasn't even expecting this. Okay. People, thank you, Sonia, Chris. Thank you extra so much for that. Your support is ridiculously generous. All of you, even just being here in chat is ridiculously generous. Even clicking the like buttons is generous. Thank you so much, everybody. Our third guest.
Oh,
we have confused Strawberry wondering, where did my bottle go?
Where did my bottle go? Give me my bottle back. She's like, damn it, Dad. I needed that bottle. I was having so much fun.
Here, lay down on your stupid blanket, you dumbass.
She's like, but I wanted the bottle. She's so sad.
All right.
Straubs.
Jeff, we covered.
What am I gonna do now?
The Sarah Boone pre-trial conference. I'll watch it. If it's interesting, we'll cover it. We'll have to see. I'm not expecting much. I'm expecting them to go, we're not ready for trial. And they'll go, okay, we're not going to have the trial next week. I'm pretty sure that's all it's going to be. But I'll watch it. If it's interesting, we'll talk about it. All right. Nowhere close to Sarah Boone. Yeah. It's just trial is supposed to start next week, but it's not going to. There's no chance in hell it's going to start next week. MG Law saying, I wouldn't be surprised she's had a hysterectomy and can't get pregnant. It's always a possibility. Who knows what's going on? Aw.
Maybe there's a bottle somewhere in this blanket. She's like, she's giving her ass to the camera now.
Just sitting in front of the space heater. All right. So that is the motion to file. Now let's look at what the amended response to the complaint is. Schrodinger's pants is fun too.
We were talking about how you're wearing pajama pants, and I said at least he's wearing pants, and then they said
my fuzzy sky blue pants with little hearts on them.
And I said at least he's wearing pants, and they're like Schrodinger's pants, because we don't know whether we're wearing pants or not. It could be pants or no pants.
Normally I'm not, but yeah. So, but yeah, I also have purple ones with little orange, with yellow and darker purple cats on them. So anyway, they're like $2. They're so freaking comfortable. Anyway, enough about my pants. Amended response to petition to establish paternity. Respondent Clayton Echard, yada, yada, yada. Background. Petitioner has not provided any verifiable scientific evidence that she is pregnant, and all DNA tests have come back showing little to no fetal alcohol.
That
little
too.
to no fetal DNA. The testing company Ravgen has indicated it will not release records of the testing without a court order. Petitioner has filed her petition only after respondent indicated that he did not want to have any relationship with her, romantic or otherwise, after she performed oral sex on him on May 2023. So again, that's an interesting time thing. She's like, oh, we're now boyfriend, girlfriend. He's like, yeah, I don't think so. Thanks for the blowy. Don't ever talk to me again. And then suddenly she's pregnant and filing lawsuits. It sounds like she might want to keep him there. We'll just have to see how. There we are. We'll have to see how that plays out. What are you doing, Straub? All right.
She's protesting the removal of her bottle.
Prior to and following her filing, petitioner repeatedly threatened to go to the media about her pregnancy. And again, why would she go to the media? Because Clayton Echard was the Bachelor for one of the seasons of the hit show, The Bachelor. Clout. She'll go to the media about her pregnancy and sent respondent over 500 messages from different phone numbers and email accounts. And this judge found these messages and petitioner's conduct to constitute harassment when she granted respondent's injunction against harassment on November 2nd, 2023.
Stares forlornly at ball.
Because the ball is too far away for her to get by herself.
God, she's so cute.
I'm predicting that in a few minutes she'll start going, which is like, please give me the ball that is literally close enough I can lick.
She's not real happy about that ball, though. She really wants the bottle back. It's just such a good girl. She's not even complaining. If I took something like that away from Archie Ruckus, he would be pushing his big, huge head into me in like protest.
Yeah, we don't want to encourage her to do that, though. Anywho, there we go. So a sampling. What? Now what, Megan? What are you laughing
It's
at?
just her face. It's so damn cute with the eyebrows. I can't take it. Okay, I'll be quiet now. Read.
She was born that way. A sampling of petitioner's efforts to force respondent into a relationship. So yeah, she didn't file this lawsuit to tie him to her for the rest of time and eternity until after he said, "You're crazy and I ever want to see you again." Here's just a few of the things she's done in addition to the 500 texts and emails and whatnot she sent. Petitioner, that would be Jane, drafted a contract for respondent to sign that promised for a period of 1 week while determining the best course of action for their pregnancy, Party A and Party B will exclusively explore a relationship with intention.
Can you imagine getting this from someone? This
She
literally is what she wrote in wanting him to sign a dating contract.
While they determine the best course of action for their pregnancy. She wanted to contract, to bind him by contract to be in a relationship. First of all, you can't do that. Second of all, that's just ridiculous. There is no obligation to engage in intercourse if either party is uncomfortable with the act.
Oh, my Lord.
You think he might have reservations about that, even if he were to go along with your cockamamie idea? Probably not big into sex with you at this point in his life. June 20th, 2023. She says, I have offered to give you control over the outcome of the pregnancy if we date exclusively and care for one another.
Oh, good Lord.
As a woman, what the hell, Megan?
This is a bad idea, ladies. This is desperation. Like, this is the kind of desperation you feel and think about, but you don't act on. You know, like, I know I've been there. We've all been there. You know, we've all been as women, especially when you're immature and growing up and you really want to be in love and you really want to meet somebody. You have these desperate thoughts, right? You just guys who aren't into you that you're into and they're just not into you. And it's hard to get over that. But these are the types of things that you write in your journal and you never, ever, ever show to anyone ever again. Okay.
Right.
It's don't do this. Don't do this ever. Write a novel about someone who did this. Don't actually become someone who does this.
No, I mean, but in what world would a woman, I mean, does it really go through people's minds? Like, oh, if you'll just date me, I'll let you decide what to do with my pregnancy.
I don't think so. I mean, that's like the height of manipulation. I've never had a thought like that. I've been like desperate to have somebody, you know, love me back. Sure. And you come up with all sorts of like, well, maybe I should do this or maybe I should do that. But it never occurred to me, maybe I should drag him through court and destroy his reputation in life. And then he'll love me.
He'll love me.
That's insane. You know,
Eric Holmes says, how old is this bitch? She's like 32.
She's 33. I think 33.
Somewhere out there. Yeah.
It's just, it's really sad. And it obviously is like there's something wrong. Clearly, there's something wrong.
Fellas, keep your junk out of crazy. That includes the mouth.
Yeah, when they say don't stick your dick in crazy, they mean, you know, anywhere. Don't.
Anywhere. Yeah. Yeah. And now we have a side profile of loaf of bread. All right. I have offered to give you control over the outcome of the pregnancy if we date exclusively and care for one another. We're contractually obligated to care for each other. I need to know your decision tonight because I'm getting rid of the abortion pills. It's a no, or if I don't hear back from you.
This is the weirdest thing ever to be like,
yes. All
right, I'm going to get an abortion if you stay with me. But if you leave me, I'm going to have these babies by myself. What? I mean, I'm not for abortion, but if I were the kind of person who was, I think that decision is supposed to be made the other way around. Like, I don't have any support, so I can't really have these babies. Not now I'm just going to go for revenge. Revenge babies is a very strange thing.
Well, Celicia here says, I just don't understand how this can go to court. This is one of the beauties of the legal system. You can sue anybody for anything.
Well, the family court really ought to start instituting a new policy after this, where in order to file a petition for a parenting plan, you have to provide absolute proof of pregnancy that is medical records, not an HCG test.
We'll put Doggo Cam back on when Strawberry wanders back into the room. She's gone to get some water, it seems.
Where's Yoda?
Sleep on the sofa. It's past Yoda's bedtime. He's tired. All right. So when she comes back on, we'll pop it in there. That's weird. Petitioner. Okay. To finish answering the question, anybody can sue anybody for anything in court. It's just what can you prove, and then what's the recourse after that? How much of the costs do you get? And they're usually not all of them. All right, there we go.
I love how she cozies up next to the heater. It's so funny. She's so close to it.
With Doggo Butt on display. We're wandering.
She got a new toy, didn't she? She went and got a new toy.
She got another ball that looks exactly like the one that was 2 inches in front of her face.
She didn't like that one. That one was just not right.
It wasn't. All righty. Speaking of not right, let's get back to Jane.
No!
Petitioner threatened to post her public Instagram account that she was pregnant with respondent's children if he did not unblock her. And said, if I can't get you to do it, then maybe the public can convince you to. That's just normal people don't say shit like that.
No.
Petitioner contacted respondent's father. They don't do this shit either, by the way. Petitioner contacted respondent's father, ostensibly to convince him to force his son, respondent, to speak with her. I have not heard back from Clayton and presume he still has me blocked. Can you please tell your 35-year-old son to talk to me? Or however old he is. I just guessed.
Yeah, he's 30-something.
While the family case was pending, petitioner posted an anonymous blog on medium.com, which he later deleted, contacted the news media and made multiple postings on reddit.com, claiming she was pregnant with respondent's children and including a Dropbox of doctored medical quote-unquote documents. Yes, they're here in exhibit number 7. Because they're public now, biatch. Despite
I don't think I've seen these. This should be fun.
Yes. Despite 2 fetal DNA testings indicating little to no fetal DNA and 1 lost in transit, petitioner posted another Medium.com article identifying herself as the anonymous woman on December 8th, 2023. In the article, petitioner continues to maintain she is pregnant with twins by respondent. Well, here's the response to petitioner's petition to establish paternity. Respondent affirmatively alleges that petitioner is fabricating pregnancy as well as refusing a pregnancy test. Respondent affirmatively alleges that neither pregnancy nor paternity has been proven. Respondent contests that petitioner is pregnant by him and therefore venue is not relevant. Respondent contests that petitioner is pregnant by him, and since petitioner is unwilling to participate in a 4th paternity test, paternity and the jurisdiction for determining the validity are unable to be proven or determined. Respondent contests that petitioner is pregnant by him and affirmatively alleges that petitioner has neither proven pregnancy nor respondent's paternity. And respondent contests that petitioner is pregnant by him, and therefore there is no legal parenthood to establish. First of all, say she's not pregnant, and even if you do say she's pregnant, say it ain't mine. Respondent alleges that only oral sex was performed between the parties. Respondent further alleges that despite multiple requests to do so, petitioner has refused to take a paternity test. Petitioner responded to respondent's request via email, stating that she would only take a paternity test if the parties were to date exclusively.
Oh my God. So now she won't take the paternity test until he signs the dating contract. I think she's read 50 Shades of Grey too many times.
50 Shades of Retarded. Petitioner has not established proof of paternity Upon information and belief, petitioner suffers from mental health issues. She crazy.
Gotcha, bitch.
And has caused respondent to become concerned that she is stalking him. Petitioner was not married at the time the minor children were born or conceived, or at least 10 months before the minor children were born or conceived. Respondent contests the petitioner is pregnant by him, and therefore legal decision-making and parenting time are not relevant. The respondent does not have any information regarding any court action in this state involving the minor children in question that could affect this case, including court cases for enforcement and relating to domestic violence, protective orders. This is all wording they just have to put in here. Termination of parental rights and adoptions. Does not know a person other than petitioner who has physical custody or claims legal decision-making or parenting time rights to any of the minor children in question. So you have to presume there are actual children here at some point. And then they're your alternative claim. She's not pregnant, but if she is, and she is pregnant, here's what we have to do. Respondent contests petitioner is pregnant by him, and therefore unreimbursed medical expenses incurred are not relevant. Any other expenses are not relevant. The parent information program is not relevant. The domestic violence has not occurred in this relationship, et cetera, et cetera. Okay, respondent's entitled to an adjudication of non-paternity. Petitioner's relentless and harassing behavior through the media will only continue if this matter is not resolved by the court, finding respondent is not the father of any alleged and believed to be fictitious children. Rule 26 sanctions are appropriate. Petitioner has violated Rule 26B. The Arizona Rules of Family Law Procedure and sanctions under Rule 26C are appropriate. Petitioner filed this action for the purpose of harassing respondent and forcing him to communicate with her. Despite respondent's repeated requests, petitioner has provided respondent with no verified scientific evidence proving she is or was pregnant. Further, after filing her petition, petitioner filed a motion to communicate, threatening to take her pregnancy to the media if respondent did not communicate with her. This motion was denied.
Wicked.
Petitioner's motion to communicate filed August 8, 2023. Petitioner also filed a motion for contempt, which the court also denied, which requested this court hold respondent in contempt for not communicating with her. The motion for contempt was filed, also denied by the court. As such, petitioner's petition lacks evidentiary support, is being presented for improper purposes to harass respondent into communicating with her and to cause respondent to incur fees. She's crazy. The respondent of Rule 9C have been met insofar as there has been excessive communication. So she's like, she wants us to be ordered to communicate. Well, she's excessively communicated on these issues.
God.
With recent articles and 500 plus texts and emails that predate judges granting an injunction against harassment. He's entitled to reasonable attorney fees. Petitioner repeatedly harassed respondent, went to the media. A lot of this is, okay, wherefore, there's all the orders he wants. Issue an order compelling Ravgen to produce all records and documents related to the fetal DNA testing. Sanction the petitioner. Award the respondent reasonable fees. That's what he wants. And anything else the court decides that he wants to do. And of course, there's tons of evidence back, tons of documents. Ooh, before we do that, let's check out our super chats. We've got one new one.
Great. I'll be right back. I got to turn off the space heater because now it's getting too hot in here and I'm in this blanket. So hold on a second.
Okay. And been there, done that. Thank you so much for a new bottle to give to Strawberry. I'll give her this bottle back as soon as we finish the stream, but I'll use that $2 to buy me a new bottle to drink so that I will have an extra empty bottle to give to her in due course. Thank you so much for all of these super chats and supports that have come in so far. No, Sarah, no. Baby needs a dog bed being abused. No, we can't have nice things with these dogs. They have a very they've essentially claimed the ancient $4,000 Italian leather sofa that is now just like shot to hell. Now I'm learning at this age in my life, just spend a couple $100 on a sofa and then you can buy like 10 sofas for the price of one. And they they've taken over the sofa. They have a very, very comfortable sofa in the living room. In here, if you buy them little dog beds, they just go, oh, look, something soft. Let's pee on it. That's all they do. So as has been witnessed previously on Doggo Cam.
Oh, no.
Here's a new bed you spent $50 on. Now it's a toilet. Yeah, so
Mr. Fox just just bought Archie Ruckus a bed, and it's like a round one, but it's a
Yeah.
little small for a German Shepherd. And I was like, I don't think he's gonna fit in that. And he was like, it's fine. It's gonna be fine. This dog literally curls himself into a tiny ball just to fit in this bed. And every time I see him, I walk by singing "Fat Dog in a Little Bed." Fat dog in a little bed. It's hilarious. No. He squeezes himself right in there.
Oh, that's cute. No, mine just pee on him. Volpe Fuck says my dog licks her bed nonstop. Well, that's what they do. Well, you can see like the sofa. It's a gray sofa. There's like there's like 3 black spots where they just go all day. So they've licked the dye off the leather. But anywho, enough about doggos. Let's talk about the other biatch in the room, Jane.
No.
Oh, but first, Island's bringing the $5 heat. Thank you so much for the support, Island. It is the age-old story. DJs from a stranger, mouth pregnancy, coercion, social media, and now he just can't live without her because he's not.
Because he's not allowed. God, this would make a great movie. I'm telling you, I'm sure that this is going to end up on Netflix. Yes, it would.
This would make a terrible movie. Everybody would go, "Oh, bullshit! This is
single white female, Fatal Attraction, single white female, Gone Girl. These are all these. This has the makings of an incredible this generation's horror movie, just like 1986 was 87 was the year for Fatal Attraction.
This story is so weird that you couldn't write a believable. Nobody would. This would fail miserably because like, okay, this is too stupid. This is just too dumb. Nobody's gonna buy this shit for a minute. Oh, and Sonia Chris has gifted 5 Legal Vices memberships. Thank you so much. Well, I guess now before we get into this is a good time. Thank you so much for those gifted memberships. We had a good members-only stream on Sunday. You can go back and check that out for you new members. And in addition to the members, I just want to say again a super special thanks for everybody that super chatted thus far, and those of you that are just here watching in chat. And I would ask a favor. There's 576 people here watching right now. 377, like it's like 200 of you haven't done your job. 200 of you just pop on down there right now in the next minute and a half while we talk about other things before we get back into the motions. Just get down there and click that like button. It's absolutely free. It doesn't do anything, and it makes me stop talking about it. So do that, and then come over here and take our like and subscribe poll. And also, if you haven't done so, please subscribe to the channel. We're going to be covering this case. We've got a YNW Melly double murder case coming up. We got Sarah Boone. We got Courtney Clenny, the OnlyFans killer. We've got everything we can possibly fit into here. We've got another Murdoch hearing on Becky Hill coming up on the 29th for 3 days. There's lots of stuff happening. Follow me. We do a lot of fun stuff here. Then take our like and subscribe poll. What's the weirdest part of this case? So far, 8% of you say fetal attraction. 12% of you say Jane.
No!
24% of you say mouth conceptions about pregnancy. And full 56% of you say just the whole damn thing is weird. All right, we'll check back on that in about 45 minutes when we wrap up here. Oof. But yeah, so please hit the subscribe if you haven't done so. And if you are subscribed, just double check to make sure you still are, because YouTube is asshole and just kind of decides to take.
YouTube is asshole.
What YouTube giveth, YouTube taketh away.
Jeff, how come you don't have a Rumble channel again?
Because I can't monetize it here in Korea. So why?
You can't monetize it at all?
No, it doesn't talk well with Korean banks. Their payment system.
Oh, because it's Stripe or whatever?
Yeah.
Oh no, it's PayPal. Rumble is PayPal.
Whichever one. It's Stripe, and I didn't know they did PayPal too. But anyway.
Yeah, no, they do. No, Rumble is PayPal. Locals is Stripe. You can. It's PayPal. So. But
PayPal still does the same thing here because they don't have like the friends and family thing in Korea because of banking laws. So just like YouTube, PayPal takes 30% off the top.
Oh, geez.
So it's the same thing. So why have another thing to complicate my life? But yeah. I do use Rumble as the storage for all of my videos. Everything gets backed up to Rumble.
Oh.
So you can still go there.
Okay, so you can still watch stuff there.
Yeah.
Okay, hear that, locals? We have a little revolt going on in locals for YouTube because I guess they're doing something to viewers if they use ad blockers. They're slowing down your system, and they're not happy with that. So I don't know.
Yeah.
We should probably follow that, see what's going on with that at some point.
Yeah, that's pretty much what they're doing. That's kind of it. All right. Well, thank you everybody for that again. Thank you for being here. Thank you for chatting, super chat, support the memberships, your monthly membership freebies, things like that. Thank you so much, even just for being here. And check me out. Check out also Megan Fox at megan.locals.com, who is aggressively covering this case and all the tangential issues. And just about 45 minutes from now, she is going to break some super, super interesting stuff in the Maya Kowalski case.
Yep, the judge has ruled on some new stuff, so you're going to want to hear about it.
Stand by for news. Because Megan Fox has got it. MeganFox.locals.com. Megan Fox reporter here on YouTube. Do not miss it, because 45 minutes from now, she's going to be dropping some cool breaking news, and I'm going to pop on over there and say howdy for about 30 minutes as well. All right. With all of that stuff out of the way, let's move on to this, the motion for sanctions. This is, I want money. I want her to be punished. I want her to pay. That's what we're asking for here with the motion for sanctions. The petitioner filed the underlying action for an improper purpose without medical evidence to support her claim that she was pregnant and or that she was pregnant by respondent. Petitioner could not have become pregnant from the limited encounter the parties had and therefore premised this entire action on a fiction. Petitioner violated Rule 26B-1-3 in her petitions and subsequent filings. This matter arises from the establishment petition filed August 1st, 2023. Also pending before the court, here's all of these this is everything that's pending before the court. All of these motions, all this bullshit. Rule 26B of the Arizona Rules of Family Law Procedure provides as relevant here that by signaling a pleading, motion, or other document, by signing. So this is when the lawyer signs off on the pleading, motion, or other documents, the attorney or parties certify to the best of the person's knowledge, information, and belief formed after reasonable inquiry. So the lawyer that signs off on the document, I don't know if she filed the original. We don't have it, so I don't know if she filed the original petition by herself or if she had a lawyer do it. But if she had the lawyer do it, the lawyer can't go, oh, well, that's a wild and crazy story. Thank you very much. They have to do a reasonable inquiry. They have to do a bullshit test. And they have to, everything in that document, they have to either know or believe after a reasonable inquiry. One, is not being presented for any improper purposes, such as to harass. Two, the claims, defenses, and other legal contentions are warranted by existing law. And three, the factual contentions have evidentiary support, or if specifically so identified, will likely to have evidentiary support after a reasonable opportunity for further investigation or discovery. Well, Rule 26C provides that if a pleading, motion, or other document is signed in violation of this rule, the court, on motion or on its own, may impose on the person who signed it, a represented party, or both, an appropriate sanction, which may include an order to pay to the other party or parties the amount of the reasonable expenses incurred because of the filing of the document, including reasonable attorney fees. Well, the requirement of Rule 9C have been met, and a good faith consultation certificate is attached here too. See also respondent's motion for leave to attend, all these other motions. Now the sanctions are appropriate and warranted. Echart's lawyer alleges petitioner's behavior. That petitioner, remember, is Jane.
No!
Her behavior is the exact type of conduct that Rule 26 is intended to sanction. It's like they made this rule just for her. Petitioner was never pregnant by respondent and filed this underlying action in bad faith and with the sole intent of coercing respondent into having a relationship with her. Yeah. Petitioner's commencement of this action and original filing was made for an improper purpose under the rules. Back to the sexual intercourse. Petitioner instigated this action where she filed her petition to establish paternity, legal decision-making, parenting, and child support, which is alleged she had sexual intercourse with respondent, became pregnant by him, and requested this court enter orders for joint legal decision-making, a parenting plan, and order respondent to pay her child support. Petitioner's petition to establish was filed for an improper purpose because petitioner was never pregnant by respondent and could not have become pregnant based upon their one, parentheses, numeral 1, in case you didn't figure it out, 1 encounter of oral sex on May 20th, 23.
Good
I feel
Lord.
bad for Echard that everybody in the world knows what day he got a blowy from a random stranger.
Oh, great.
We know what you were doing on May 20th.
He did say that he took an edible, and that this was the reason why he wasn't thinking straight. She did too.
She got an edible.
Oh,
Yeah. Despite, anyway, moving right along, despite no underlying orders, petitioner filed a motion to communicate on August 8th. The court denied, and a motion to compel on August 23rd. The court denied both motions. Respondent filed a response on August 21st, denying that the petitioner could be pregnant by respondent after one incident of oral sex on May 20th, 2023, in case you missed that date, when petitioner did not get what she wanted, including attempting to get respondent to enter into a dating contract. He already did that on The Bachelor. He's already had one of those once. She went to the media, Reddit, The Sun, incredibly reputable sources, The Sun and People Magazine and Page 6 and Medium.com, and Reddit, all of the world's top leading news sources.
And yeah,
The police, respondent's father, and even threatened self-harm. Ugh.
Ew.
Emotional blackmail sucks. And if someone threatened, never mind, I'm not going to finish that sentence because,
Well,
when
but
the media
truly
yes.
though, when someone threatens something like that, and she's done it multiple times, when we've seen through these court documents to other people, it loses its sting at some point. Like, this is not a serious person. Just saying.
When the media turned on petitioner and had doubts about the veracity of her pregnancy, as no verifiable medical evidence exists, petitioner obtained an order of protection against respondent based on cyberbullying. Respondent obtained an injunction of harassment against petitioner based on the receipt of 500 plus harassing messages. During the proceedings on November 2nd, petitioner wore a fake stomach moon bump. We'll watch that. We'll watch. I know you've watched the hearing.
Mm-hmm.
We're going to watch that hearing too, where this woman who is 6 months pregnant stands up for an entire 2 hours just so you can see
going
her
to the
baby.
bathroom even once.
Yeah, while chugging Monster energy drinks.
When I was pregnant, like within 5 weeks of being pregnant, I was in the bathroom every 15 minutes. It's bizarre. It hits you right away. You have to pee all the time. And if you're drinking, there's no way you could go 2 hours without a pee break. No way. At 7 months or 6 months pregnant with twins, no.
While poisoning them with the Monster energy drinks.
Poisoning them with Monster. She won't have fetal alcohol syndrome. It'll be fetal monster syndrome.
Yeah, whatever caffeine does to you. Yeah. So she's wearing her fake moon bump to appear pregnant and claimed with no scientific support that she was 24 weeks pregnant with respondent's twins and due on Valentino's Day, February 14th, 2024. Petitioner then sought to have this court enter orders against respondent despite no verifiable proof petitioner was pregnant and no child subject to this court's jurisdiction by filing an application and affidavit for entry of default. Despite providing no verifiable medical evidence that she was pregnant or that she was pregnant by him, only positive HCG tests and fabricated sonograms, petitioner sought to force respondent to communicate with her and threatened to go to the media if he did not comply. Notably, in her motion to communicate, petitioner requested respondent is ordered to communicate with petitioner. The respondent was the Bachelor on ABC, and the petitioner knows it would be in his best interest to keep the details of this case out of the public eye.
Oh my God, that's extortion.
Yes, we call that extortion and or blackmail. Also, in her motion to compel, petitioner admitted that she had requested a 1 to 2 week trial relationship prior to filing her underlying petition and asked the court to hold respondent in contempt of court for not talking to her.
Can you imagine what that week would be like if you said okay to that? Like,
I asked him for a contractual 1 to 2 week trial relationship where we were required to care about each other and be serious, and he ghosted me. I want you to make him talk to me.
Required to care about one? Oh my God, woman. Yes. You cannot require someone to care about you.
Yeah. Petitioner's own words prove that she instigated this entire action, including fabricating a pregnancy to coerce respondent into talking to and dating her. And the motion is unsupported by existing law. They just go through as discussed more fully in the response to that motion, Arizona law is crystal clear that jurisdiction attaches at the time the action is filed. Subsequent events and acts by the parties cannot deprive the court of jurisdiction once attached. So this is all just legal jurisdictional stuff that's not nearly as interesting as the sordid details of this. And her factual contentions are not supported by evidence and did not become supported by evidence after investigation and discovery. The petitioner lacks evidentiary support beyond petitioner's assertion that she was pregnant with respondent's children. Admittedly, any establishment petition made prior to the birth of the children is necessarily lacking evidentiary support. But they'll have evidentiary support after a reasonable opportunity to investigate it. Essentially, if you claim you're pregnant with twins and you're trying to establish something through a petition, all you have to do is wait for the twins to be born, and then you'll have your evidence. Unless there's no twins to be born. Yeah. In this case, however, petitioner's claims were never true and could not be true because the parties did not have sexual intercourse requisite to conception. Requisite to conception. I like that. In matters where pregnancy and paternity are contested, Title V contemplates subsequent testing either before or after the birth of a child to establish the necessary factual support. Well, since filing, the petitioner has provided no Rule 49 disclosure and seeks to avoid a deposition. She doesn't want to be deposed.
She's supposed to be deposed tomorrow.
Oh, is it 18th? Okay.
I think it's the 17th. That's
today. For me, anyway.
Well, for you. Here, it's the 16th.
Okay, I thought it was the 19th. But either way, it's supposed to be. Maybe that's what Dave has for today.
Perhaps, yeah.
Ooh. That'd be fun.
I've been kind of looking at his Instagram. I haven't seen anything yet.
Dave, hurry up and post something. We're waiting.
Hurry up and post it, Dave.
She has participated in fetal DNA tests, none of which have conclusively established the existence of pregnancy or respondent's paternity. At least 2 fetal DNA tests have come back with little to no fetal DNA, indicating that not only was petitioner not pregnant, but she was not by the respondent, but she was not pregnant at all. Petitioner carefully alleges in a motion to dismiss that she is no longer pregnant. That's all she said. She makes this motion to dismiss the case and says, I am no longer pregnant, but refuses to provide evidence of the termination or miscarriage of the pregnancy, e.g. fetal death certificates, which are required by law in Arizona at this point in a pregnancy. It is critical for this court to take evidence and investigate whether petitioner was ever pregnant in the first instance, both for the purpose of declaring non-paternity and for determining the appropriateness of Rule 26b3 sanctions, and also for determining whether she committed murder. Because if she would have had this at a hospital, there'd be death certificates.
Yeah. Where are the babies?
Yeah, she's got to prove something, and there's some severe criminal violations for something if that actually happened, and there's no records of it. Even if respondent did not request sanctions, which he previously did and now reiterates by separate motion, this court may investigate and impose sanctions on its own motion. Rule 26 requires signatures on pleadings and filings and attaches substantial meaning to those signatures. A person filing a document certifies to the court that it is being presented for a proper purpose and is supported by law and evidence. The rule requires parties and attorneys to conduct at least a reasonable inquiry before signing filings, and sanctions exist to ensure compliance. Vindictive misuse of the court's resources and authority, and to make responding parties whole for frivolous lawsuits. Respondent asserts that the circumstances of this case are so egregious that this court ought to impose sanctions on its own, even if for no other reason than to deter specific and general abuse of process. So give us what we want. That's the motion. We've got a lot of motions today. Whew. But so that's the motion for the sanctions. Makes me tired, Megan.
This should make you tired.
How much crazy?
Imagine how exhausted Clayton Echard and Greg Gillespie and Mike are. The three men have been dragged through court by her. Greg Gillespie was dragged through court for 4 years by this woman. 4 years.
Coincidentally, pregnant with twins.
Right.
Allegedly.
Mm-hmm.
Eckhart contraceptive mouthwash could have fixed this.
Hey, that's a new market. It's something you guys should start making make money on this. Sounds like a great idea.
Well, see, it's the timing of this. I'm no longer pregnant that I find to be particularly egregious.
Yeah.
Your lawyer goes, fuck this shit, I'm out. And then the new lawyer comes in, and that day, apparently, she's no longer pregnant.
Mm-hmm.
So you should blame the lawyer, the new lawyer, for the lack of. You were perfectly fine and pregnant until the new lawyer showed up, and then instantly you're not pregnant anymore. Sounds like you should hold the lawyer responsible, not Echard.
I think lawyers should be required to do some form of due diligence on their clients before taking them on. Like, couldn't you just look at the docket to see how many lawsuits this person has been involved in? Wouldn't you want to know that before you take on
It's only client? 3 or 4. Weirdly, that's not a lot for some people. You get these professional plaintiffs that have hundreds of lawsuits they file. That's just what they do. They file these frivolous lawsuits. They get the companies to go, here's $2,000, go away. They file 500 of those, and they've got a huge pile of cash.
Terrible.
So this really, in the grand scheme of things, is not that many. I know it seems like a ton, but it's weirdly not.
The chat is asking why twins. There's actually an explanation for why twins.
There is.
And it's because am I spoiling anything, Jeff, or do you want me to go there?
No, go ahead.
It's because it's very difficult to test for paternity in twins. And there's only the one company, Ravgen, that does it pre-birth. And so it is Clayton's supposition that she chose twins because it was more difficult to get a paternity test and didn't think he would find the one company that does it. So she could just, keep it going until the end.
Well, see, I mean, that's the things. I was however many days old I was last week when Dave was on the stream, and he explained that there is now a test that can do this. Mm-hmm. Because previously you could not test paternity from fetal twins, because what you have to be able to say is that the fluids or whatever you take from fetus A is the offspring of, or this person A is the father of fetus B, and this person is the father of fetus C.
And it has something to do
with
like
all of the fluids are circulating between the two children, so you can't isolate where that is coming from. But now, apparently, according to what Dave was saying, now this company can do that test. I mean, before that's why apparently I would assume that she didn't know that this could be done with the new testing procedure, because that was always the deal. You cannot do paternity tests on twins prenatally. You have to wait till they're born to do it, so that you can definitively go, okay, this person over here's DNA belongs to this guy.
Mm-hmm. I think we actually hit bingo a little while ago. I forgot.
Did we?
We did, because the poorly written legal documents were quoted in the in that document you just read with her dating contract. So we got bingo. We're at bingo. We got it.
Woohoo! Yay! Let's go for blackout.
We could go for the whole card at this point.
We could. And she said, well, unless someone up here just a minute ago said, unless they're identical. But still, even then, you can't say that this particular fluid came from this fetus. It's just a matter of distinction. You have to
DNA problem. It's free floating DNA, and
you have to specifically say this is the source of this DNA, and you couldn't really do that. But apparently now you can. So. But so that answers the question of why twins, because she thought they couldn't be tested. With this one, we need a bigger bingo card.
We're gonna need a bigger bingo card.
Yeah. You're gonna need a bigger bingo card, Megan. Wait, you got the Jaws music.
I do.
Yes. You're gonna need a bigger bingo card. Right. Rip Roy Scheider, man. All right. Well,
One
hell.
of the greatest movies of all time. Jaws 1, not the rest of them. Jaws 1, the original.
1. Yeah, not Jaws 3. The
3. Jaws 3 is like the funniest, worst movie ever made, though. Jaws 3. Like with the aquarium.
Was that the one? Yeah, that was one where the child of Jaws hunted the people down, worked his way into an aquarium just so it could attack and seek revenge for its dead mother.
Yep, that's the one. Yep.
That was really bad.
My favorite thing that we do in the Midwest, I don't know if they do this everywhere, but back home in Chicago, there would be like the community pool would host a Jaws night. And you could float around at night in the pool and watch Jaws on the big screen. There is nothing creepier, awesome. Even when you're in a pool, like you're in a pool, it still doesn't matter. You're still like, what was that? It's so fun.
Well, after Jaws 3, you're not safe in a pool either.
Nope.
All right. Well, let's move up to this one.
All right, which one's this now? What craziness is this now?
This is the objection, because she requested that she dismiss the lawsuit. It's like, okay, never mind.
Never mind.
I'm not pregnant anymore. We don't need I got my new lawyer, and apparently I'm not pregnant anymore, so we don't need the lawsuit. You know, I don't need paternity. I don't need the child support. I don't need the declaration because I'm not pregnant anymore. So no harm, no foul. Let's just let it go at this. Whereas Clayton is saying, Oh, no. This has gone on far too long, and you can't say that he made me terminate this or I was pregnant. I want you to be deposed. I want this to go on, and I want a judgment. I want this to go to a judgment. We've gone too far.
Yeah, this one is great. I love this one. This is my favorite legal document of all of them. This one is fire.
Yeah.
I love it.
An Unhung Hero says, so you're saying Sharknado was no, Sharknado is great. Sharknado was awesome.
I never saw it. I should see Sharknado. That sounds hilarious.
Yeah, it's like 4 or 5, the water spout tornadoes off the coast that just collected a bunch of sharks and just ripped through town while the sharks are like flying around in a tornado biting people as it passes. It's awesome.
Wait, you mean the tornado doesn't put them into water, like lakes and stuff?
No, it takes them up out of the water, and while they're in the hurricane, like Dorothy and the Wizard of Oz,
they're biting people.
The tornadoes are going through town, and they're like, someone gets too close, like it gets them. Yeah,
it would have been a better story if it had just deposited several man-eating sharks in different lakes and things. That would be better, and then it could be like Jaws times 5.
No, it's ridiculously beautiful.
Okay, I'll have to watch it. Sounds terrible.
Like I think they're up to 9 or 10 now, but the first ones are great. Like the first 2, I'll give them. Anyway, petitioner's motion to dismiss must be denied. As a motion alleging without any proof the petitioner was pregnant in the first place, that petitioner is now without child is insufficient cause for a dismissal under Rule 29A1. Permitting a petitioner to bring this action, seek out media attention, force respondent into a court to respond to baseless and malicious allegations in 3 different court cases before 3 different Maricopa County Superior Court judges, to then absolve herself by suddenly claiming without any evidence that she is not pregnant would be a gross miscarriage of justice.
We just got bingo again.
We did.
We did. Bamboozled court judge gave us bingo on the diagonal.
Okay. All right. We'll
3
give you
different
that one.
judges. 3
different
judges. Holy shit.
Fuck. Petitioner continues to demonstrate that she is eager to utilize the media to support her fabricated pregnancy narrative. I like that. Fabricated pregnancy narrative. And she will continue to claim that she was pregnant by respondent unless this court adjudicates this matter with a finding of non-paternity. I absolutely think that is correct. She is going to continue to say, well, I was pregnant with his children, but for whatever reason they were lost. He wants to say, oh, no, bitch, you were never pregnant. And if you were, they sure as hell ain't mine.
She will absolutely do that. She will keep on saying that she was, and that everyone should just believe her just because they should.
And I think she's absolutely entitled to this.
I do too. I will be but I got to tell you though, I don't have a whole lot of faith that a family court judge is going to do anything but go, this isn't mine anymore. I don't want it.
Oh no. Unhung hero. Miscarriage of justice.
Hey, phrasing.
Oh, that's almost enough to get you sent to the penalty box. Thank you so much, Unhung Hero, for that. Ann S says, duck fuck crazy. I guess that's really crazy, I suppose. Oh, Lordy. On or about January 2nd, 2024, just the other day, petitioner again contacted the Sun.
We can't see it, Jeff.
I don't care. I'm going to keep reading it. On or about January 2nd, 2024, petitioner again contacted the Sun and stated that she firmly stands by everything. And she had a positive pregnancy test at one point that confirmed her pregnancy. The current existence of her pregnancy is explained below as insufficient cause for dismissal. An adjudication that she was never pregnant, or at least that she was never pregnant by respondent, is what justice requires. To the extent applicable, respondents' pending motion for leave to amend all this shit here, are incorporated herein by reference. There's too many motions to just list. Petitioner's motion, as well as all of petitioner's filings in this matter, lacks evidentiary support, misstates well-established Arizona law and policy surrounding subject matter jurisdiction, and would deprive respondent of the basic access to justice after he was involuntarily dragged into court to defend himself. Put plainly, petitioner's motion cannot be granted, and to do so would be to commit grave and clear error. And as for his response objection, respondent provides as follows. A motion stating the petitioner is no longer pregnant creates evidentiary issues that must be resolved. After repeatedly claiming and insisting that she was 100% pregnant, not 98% pregnant, I think that's like an all or nothing, ain't it? I don't know. She was 100% pregnant by respondent in filings under oath in various court hearings and in hundreds of social media posts. Petitioner cannot be permitted to suddenly claim without any evidence that she is no longer pregnant. Critically, petitioner stated under oath and without any medical evidence that she was 24 weeks pregnant and due on February 14th, as of November 2023. She also appeared in court via video on October 24th with what appeared to be a pregnant stomach, upon which information and belief was actually a moon bump or fake stomach to appear pregnant. At this time, petitioner also requested judge to permit her to show respondent her stomach to verify she was pregnant. Oh, that was a great part of the hearing. She said, "Can I show my stomach?" The judge's like, "No,
no."
And here's a view of it. 24 weeks pregnant. She got her little bump here, and you know, I'm sorry, but
and is wearing flesh-colored sleeves underneath that dress.
Yeah,
those are not arms; those are sleeves.
And if I may be so crass as to point out that I've seen 6-month pregnant women, and they ain't got those small of boobs with that big of a belly. That's almost a man chest at 6 months pregnant.
My favorite part is when she pushes it up.
Oh yeah, she like readjusts it. They're like, ugh.
If she pushes it up, it goes over one boob. It's great. It's great.
If petitioner is now alleging that she is no longer pregnant because of a miscarriage, a third trimester abortion, or whatever she's claiming, her motion to dismiss curiously lacks any explanation. She must provide documentation to support the same. A miscarriage this late in an alleged pregnancy would require medical attention, if not full hospitalization. And there would be fetal death certificates filed with vital records consistent with these rules, requiring a fetal death certificate to be filed within 7 days of fetal death where the fetus is past 20 weeks or 350 grams in weight. If she otherwise disposed of the twin fetuses, a criminal investigation would be warranted to locate the remains. So I wasn't joking when I said a possible murder investigation. I was deadly serious. Petitioner must provide respondent and this court with evidence to support the existence and now the non-existence of a pregnancy. She is literally up against the ropes on this. She either has to come out and say, I was never pregnant and this was all a big lie and I committed all these perjuries, or she's got to cough up evidence both ways, that she was pregnant and evidence that she is now no longer pregnant. She's in a rough spot.
If the judge holds her accountable, if the judge is not lazy, but there is no telling what a family court judge will do.
Oh, see, we got 15 minutes. How far? What page are we on? Page 4. We can skip through a bunch of this.
I can.
Okay, we got to
push it out. I can push it out. I can edit it a little to give us some more time.
Well, I think we've got enough time to get through most of this. We got like 10 pages left, and we get to skip a little bit.
Yeah, the stuff about jurisdiction you can skip totally over because he just makes the argument for why the family court does have the jurisdiction, and it's pretty boring.
Yeah. Petitioner's ability to provide evidence or any evidence that complies with Rule 2 is highly dubious, and any testimony she provides should be carefully assessed, as petitioner is entirely lacking in credibility. As outlined in respondents' pending pleadings, petitioner, I like alliteration. Respondents' pending pleadings, petitioners provided no verifiable medical evidence to support her claim that she was ever pregnant. Instead, petitioner offered unverifiable screenshots of appointments, positive HCG tests, a sonogram taken from a 7-year-old YouTube video, and a demonstrably fabricated sonogram.
That was actually a quadruple alliteration. That was pretty amazing.
That was good.
I don't think I've ever seen a quadruple alliteration. That's good.
One of 3 fetal DNA tests, 2 have come back showing little to no fetal DNA. 1 was allegedly lost in transit. A conclusive paternity determination has now been made impossible, as petitioner refused to comply with the 4th test and ostensibly has determined that stating she is no longer pregnant will allow her to evade the paternity issue and continue to perpetuate the false narrative that she was pregnant by respondent. The court must be provided with concrete and verifiable evidence to establish this critical fact, that petitioner was pregnant by respondent and is no longer pregnant with respondent's twins, to determine whether there is a cause to go forward. Without belaboring the point, petitioner has not provided any disclosure, any verified sonogram reports, any fetal anatomy scans, any sonograms from weekly checkups, any documentation to support her statement under oath that she was 24 weeks pregnant on November 2nd, any medical record supporting the existence of pregnancy at all. She refuses to sign a simple HIPAA form to permit the release of records from the various medical professionals that she claimed under oath that she was being seen by for her high-risk pregnancy. She now seeks to have the action she filed dismissed by claiming she is, quote, no longer pregnant, still without providing any evidence to support the same. This cannot be permitted. To resolve this action, petitioner must prove with evidence in compliance with Rule 2 that she was pregnant due to the conduct on May 22nd, 23, that she was pregnant with respondent's twins, that she is no longer pregnant with medical records confirming the date and week of gestation that the pregnancy terminated. Petitioner simply cannot evade her evidentiary burden, as respondent is entitled to a resolution as to whether she was pregnant with his twins, and if she was pregnant, what happened to the twin fetuses. We can skip over the subject matter jurisdiction. And while we're skipping over that, I just wanted to point out something very, very nice here. Duncan, Idaho, thank you so much for the $2 super chat. Megan, that's just a normal pregnancy belly.
Sure.
Yeah.
Sure it is.
Sure, yeah. 6 months, and you can't really shift it up over a boob. That's not how it works.
Yeah, that's really, I wish it did, because that would be really helpful for when their little feet are, kicking you directly in the bladder to be able to move. I tried moving them. I would push on it all the time, but you just can't. I would try to stand on my head, do all sorts of things to get them out of there.
Just gas.
Oh, it's awful when they've got a foot lodged in an organ. And it's
Bifrons, just to clarify, she's admitted that there was only oral copulation, or she claims to be pregnant from that.
No, she's admitted it.
Well, she's only said, what was the word she used? She used intimate contact.
But in the email that she sent to him shortly after that, she admits that they had no sex because she tells him that he would believe her if he was inside of her and knew how tight she was.
Thanks for going there, Megan.
Well, I'm quoting. It's a quote,
Yeah.
She thinks that he would believe her about the paternity if he was ever inside of her. So that means he wasn't.
Yes, but to answer the question that was asked, no, she's not made any such admissions in court. She's only said there was intimate contact. She has refused to explain what intimate contact means.
And by the way, it just goes to show how little she knows about pregnancy, because pregnancy hormones actually relaxes everything. So everything is looser. Okay. Just letting you know that would actually not even be true. So whatever.
There you go.
The more you know.
The less you really wish you had known. That petitioner is allegedly no longer pregnant, does not divest the court of jurisdiction. The requirement for sanctions has been met. We already went through all the sanction stuff. If this court determines it has not been met, compliance with the rule will be futile. Respondent paid for and engaged in 3 different paternity tests to further disprove the possibility to petitioner in the hopes that medical science would resolve the issue. Nothing would deter her, not even 2 DNA tests showing little or no fetal alcohol. I said it again. Little to no fetal DNA. Respondent has more than complied with Rule C. It's Jane.
No!
Please check your email. RavGen closes soon. I want to do the test. I need you to respond, though. You want to do the test with no stipulations? You're going to be forced by the court to meet with me, Clayton. You may...
Oh, my God. You're going to be forced to meet with me. What happened?
You're going to be forced by the court to meet up with me, Clayton. You might as well go along with the stipulation since it means 100% I am doing the test. So if we meet up once in a very public setting, like a coffee shop, you'll then take the test afterwards? Takes so long.
You are going to be required to do that regardless of whether I take the paternity test now or in February. Wait, I need more vocal fry. No, it's with the week's worth of stipulations and hopefully more, but absolutely no requirement in order for me to take it early. Again, it's all for you. I know who the dad is. You. I'm doing you a favor here by offering something. I think
the app gave me a new number, but it's Jane.
No!
Sorry. Get that creepy voice out of here. Anywho, so she's like, meet up with me in the presence of a mediator. No, that's not. We're not going to meet up with you in the presence of a court mediator. That's not how it goes. The whole point is not to waste the court's time. You meet in public at a coffee shop. You want to talk about this in public? Yes. Yes, I do want to talk about this in public.
You're forced to meet with me, Clayton. The judge is going to force you, Clayton. You will meet with me, Clayton.
Just, sorry.
Yes, in a setting where people and security cameras are. All right, enough of the voices. Stop it, Donald. Stop it. It won't go away. And so, yes, he's going, yeah, I really do want to talk about this in public with people around and cameras. Smart man. She's like, you don't want to bring all this up in public, do you? Oh, fuck yeah, I want to bring this up in public.
If you were doing Trump voice, it didn't work.
Didn't?
Your filter didn't go on.
Oh, no, not even for the creepy girl?
Uh-uh.
Stupid thing.
I didn't hear it.
No!
Well, that works.
That one worked.
Oh, well. I don't care. Who cares? Doesn't matter to me. Aha. It wasn't turned on.
Oh, that would make sense then.
Now it'll work. It just wasn't turned on. He's stupid. He's the worst. He's dumb.
There it is.
There we go. All right. So that was like, oh, well then.
nobody heard my creepy girl voice. Damn it. It's the ghost of twins past.
Oh,
right.
that is creepy. That sends chills right down my spine.
Damn it. Okay, anyway. Should the court determine the respondent communications with petitioner are insufficient, the compliance would have been futile as both parties restraining orders against the other. Petitioner even went as far as to threaten to harm herself if respondent did not communicate with her. Petitioner's relentless crusade to accuse respondent of impregnating her, lash out at anyone who disagreed with her, made it impossible for respondent to try to explain to her that she was not pregnant by him and could not be. I don't think you really need to explain that. If you need to have that explained to you at 30-something years old, you got probs. But plainly, respondent could not guarantee his safety around petition, which led him to seek an injunction against harassment, which was granted. Therefore, Rule 9C was either met long ago or could not have reasonably been complied with. Respondent is entitled to an evidentiary hearing on his request for Rule 26 sanctions and attorney fees. We just read about that there. She has steadfastly insisted she's 100% pregnant, despite offering no verifiable evidence as oral sex does not result in pregnancy. The petitioner suddenly admitting she's not pregnant. Only after respondent filed his amended response to end notice of non-paternity does not address whether she was pregnant to begin with or whether she was pregnant with respondent's twins. Respondent is entitled to a minimum compliance with discovery aimed at determining whether she was pregnant at all, and records from the doctor she testifies to being seen with under oath, and an opportunity to be heard for his requested relief. Respondent is entitled to reasonable attorney fees regardless of the source of the fees, for plain reasons. He's incurred thousands in attorney fees, thousands of dollars in attorney fees. I'm pretty sure it's tens of thousands.
Yeah, Greg Gillespie spent over 100. Sick. I think there's enough guys now that they might be able to. Can you class action sue someone in civil court for defamation? Since they're so similar, these claims, do you think you could get together and just all three of them sue her at once?
That'd be fun.
That would be hilarious. Do you think that's ever been done?
Nah.
I think it could be, though. I feel like if you can think it, you can make it happen. That's what I think. Kind of like Twins by Blowjob.
This here is probably my favorite part of the whole thing. It is not respondent who is inappropriately attempting to utilize the family court's resources. As further demonstration of her unreasonableness and for the sole purposes of attorney's fees, petitioner refused to sign a stipulation to dismiss this action, as she claimed that stating she was never pregnant by respondent would be her committing perjury. So what he did is he said, okay, I'll allow you to withdraw this if you sign this affidavit, this stipulation saying that you were never pregnant and you were never pregnant with my kids. If you do that, I'll let you walk. She said no, because if I signed that saying I was never pregnant, I would be committing perjury. Well, it is frankly astonishing the petitioner is now concerned with perjury. Right. After repeatedly perjuring herself in 3 different court cases, and despite the only evidence of paternity showing little to no fetal DNA.
Good Lord.
12/27/20. This resolves now or in court with Ms. Jane admitting she was never pregnant by Clayton. Her exposure at the evidentiary hearing, which we will insist on, is testimony and evidence before the court that she was never pregnant by anyone and that she fabricated medical documents. In addition to repeatedly lying under oath, I appreciate that your client wants to put an end to this. These are emails between the lawyers, by the way. This is one lawyer talking to another. I appreciate that your client wants to put an end to this. Due to her past behavior, we have legitimate concerns that this will become another situation where she runs to an outlet, TED Talk, Medium, etc., to clear her own image with a fabricated story after she brought this upon herself by filing her petition and reaching out to social media. The proposed language in the Exhibit A, which was the admission, will prevent her from doing this. As you are aware, your client has a history of lashing out against anyone who sees the world differently than she does. And that appears to be most people.
I think we can check off cluster B disorder, I think, with that sentence.
You think so? Okay, cool. So, be it the bar complaints, allegations that I was somehow involved in coordinating a sexual assault on her, claiming that was the other thing in the Gillespie. This is Gillespie's. I guess this is from Gillespie's lawyer. She actually told the judge
it's the
in
same
the court.
lawyer.
Yeah.
Clayton has the same lawyer that Gillespie had.
Why am I today years old when I just found that out?
Yeah, they have the same lawyer. His name is Greg Woodnick.
Woodnick, yeah. Okay, I didn't know. Oh, I did not know that. Yeah.
Well, he had to drop out of Mr. Gillespie's case after she fabricated sent that email to the judge, alleging that he had kidnapped her and done weird things to her.
Yes, that is literally what she said in this letter to the judge. She said, I mean, this is while the trial is going on, that Mr. Gillespie and the lawyer drugged her and raped her.
Yeah.
She said that to the judge in a letter.
And I think at that point, Woodnick was like, okay, I'm out of here because this is insane. But he did, when he found out about Clayton's case, he took on Clayton's case because I think he realized, oh my God, she's a serial accuser.
That makes sense.
Yeah.
Be it the bar complaints, allegations that I was somehow involved in coordinating a sexual assault on her, claiming under oath that Mr. Gillespie hacked into her email accounts and fabricated text messages. She even lashed out at Clayton, contacted his family, slandered him, impacting possible work opportunities, and overtly attempted to harm his reputation. All based on the most unhinged effort to preserve a relationship that never was. She can end this by acknowledging she was never pregnant by Clayton. The response the next day, Jane is not willing to commit perjury by signing the affidavit you sent over. The court will not be able to order her to sign it. She concedes she is not pregnant. Therefore, there cannot be a finding of non-paternity for a non-existent child. Clayton's only viable claim at this point is for attorney's fees. If he insists on proceeding with a deposition when a motion to dismiss is pending, he's racking up needless fees. And based on all of this shit that's gone on, respondent respectfully requested this court enter the following orders. Deny petitioner's motion to dismiss in its entirety. Issue an order declaring respondent was not the father of any children carried by petitioner, or in the alternative that petitioner was not pregnant due to conduct with respondent on May 20th, 2023. Issue an order compelling Ravgen to produce all records. Issue an order compelling Vital Records to produce all records and documents related to fetal death certificate under the alleged fetus twins born to petitioner. Schedule an evidentiary hearing on the Rule 26 sanctions and for other such relief that the court sees fit. There's one more thing that we're not going to get to today, which is the respondent's response to the motioner's motion to quash deposition. We'll look at that next time. We've got to wrap this up. Megan's got some seriously hot breaking news to break here in the next few minutes. So I'm going to wrap this up. If you want to stick around, or if you want to get your thing going,
no, I'm going to get out of here because I got to take a bathroom break, and then I'll fire up the live stream when you're done. So everybody, come on over after that because we've got Judge Carroll ruling on all those outstanding motions. It is spicy AF. So I'll see you there. Thanks, Jeff.
Well, while you're doing this, give your details. Give us where, because I'm going to be setting while you're talking. I'm going to be setting this up too.
Sure, Megan Fox. meganfox.locals.com is where you can find me. And of course, I will be on YouTube and I'm on Rumble. Megan Fox investigates on Rumble. Megan Fox writer, I think, on YouTube. I don't know. You guys can find me. That's going to be coming up. The judge has ruled on all those outstanding motions. And I'm telling you, his ruling is spicy AF. You are not going to want to miss this. It is hilarious. I haven't even read through the whole thing. I have read through some of it, and it is great. It is great. It's what we've all been waiting for. J Hatch is going down. So, all right. Much like Jane Doe, J Hatch is going down.
And Strawberry. We will be there in just a few minutes. I will wrap this up and send everybody your way. All right. Thank you, Megan Fox, for being here. That's meganfox.locals.com and Megan Fox Writer on YouTube. We're going to be redirecting over there in just a minute. 605 of you here now. Thank you so much and you got the 487 likes. While I'm wrapping this up here, hit that like button and subscribe. I would be greatly honored if you would take your chance take a risk. It costs nothing to subscribe to the channel. You can subscribe and watch, or you can just subscribe and just forget I ever exist. But that would be my request. I would be honored if you would do me the privilege of giving me your subscription. Right. Here's what we're going to do. Next Tuesday was the earliest we'll get to this. Next Tuesday, we'll go back and we'll look at all of the evidence that was submitted in support of these affidavits. And then the next time we'll probably be watching the 2 hearings that she was involved. So this isn't going to go away. This isn't going to go away until we get some sort of resolution that ends with Clayton Echard getting the justice he deserves, getting his name cleared, and getting paid back for at least a portion of these costs, because this is ridiculous. We have Duncan Idaho with a $5 super chat. Thank you so much, Your Honor. Can you order the defendant to have 3X with me so he will see how tight I am and believe I'm pregnant? You can say, tell me that. Are you saying that YouTube won't let you super chat the word sex? Weird. Can you order the defendant to have sex with me? It took me a while to figure that out. Thank you so much for that super chat and for your support. Just so you all know what's happening, tomorrow is Wednesday. Tomorrow, I am going to be having on Maya Kowalski's lawyer, Greg Anderson. He'll be here for 2 hours. We're going to talk about him personally. We're going to be talking about the case, and we're going to be talking about the important and incredible breaking news that Megan is going to be talking about here in just a few minutes. But I'm going to be talking about it with the guy responsible for it. Greg Anderson will be here with me tomorrow for 2 hours, starting at 9 a.m. Eastern time. So don't miss that. And Thursday, we're going to be going through O.J. Simpson closing arguments with Johnny Cochran. And Friday is what I call Fuck It Friday, where we just say fuck it. We'd have a great time. I put on a huge panel of guests, and it's just a pure griftathon where you throw all of your money at me. Every $100 we do a shot. We just kind of get liquored up. We get drunk. We have a great time. It's all in fun. It's all tongue in cheek, and it's just so I don't have to grift for the rest of the month. But we're going to have a huge panel. This is what I call this. This is a very special edition of Fuck It Friday. It's Legal Vice's Lady Bits. It's an all ladies night only panel. And for that, we're going to be having Danny on direct, Flux from House of Flux, influencer Lauren De Laguna, Steph the Altar Nerd, Chandler Remington, Ari Jacob, the influencer's influencer, Christina from Radix Verum, who takes the government to task regularly on her YouTube channel, Talk with Sally. She has her own little channel where she does some fun stuff there. Waifu Kron Jess, AV to the 7th Power, the lead attorney's sidekick, Lady Law 5791, a quiet yet powerful lady lawyer, and comedian Lila Hart, and OnlyFans content creator Jasmine Jafar, and a possible Natalie Wisco. So those are the panel members we got lined up for Friday. Don't miss it. It's going to be a great deal. And don't forget to bring all of your dollars, pesos, shekels, whatever, rubles. Throw them all at me, and we'll have a great time. All right, everybody. Take care. Right now, we're not going to go through the whole lengthy closing. We're just going to do a very quick outro, sending it directly over to Megan Fox. If you don't get redirected to Megan Fox, there's going to be a little blue box up in the chat that says, hey, something's happening over there. Click here and find out. If that doesn't work, then you're on your own. Just go find Megan Fox, writer, and let's do it. Until tomorrow, when we have Maya Kowalski's lawyer, Greg Anderson, in studio. We'll see you later. And don't forget, next Tuesday, more of this shit. Law Rack saying peace. Oot.